Don't let your final farewell stir up family feuds. Welcome to Before You Go, a podcast brought to you by Texas Estate, Trust, and Guardianship attorneys Stacy Kelly and Keith Morris. Preserve your hard-earned legacy. Be in the know.
Hi, Keith Morris and Stacy Kelly, and we'd like to welcome you to Before You Go, Things You Should Know. And as episode 12, and we have started going through lists of questions that clients have asked us and sort of put them together into a format that allows us to answer each question so someone can refer back and make sure that they've received an answer to a question that they've had in the past. And Stacy, anything you'd like to say before we jump into this?
No, I think we're ready to go. I think this is a real quick way for people to, like you said, get questions answered and go back and listen to our answers, as they come up going forward. So,
Yeah, and we're going to have the podcast available in full with all the questions, but then also on the website are going to split each of the questions into individual little videos so that people can refer to them easily and get answers. So the first question, and this is pretty fundamental, is what's the first thing that someone should do after their loved one passes?
the first thing you need to do is get a copy of the death certificate. That's going to be necessary from all kinds of different authorities. Most of the courts require to see one, although not all do. Most of the courts do. You're going to need the death certificate, for banks and transferring title to different types of properties. And so it's just essential that you have that. And that's probably one of the first things you need to do before you think about probating a will.
And then, sort of dovetailing with that, why is it important to locate the will or the decedent's estate plan, which could include a trust, as soon as possible?
Well, one is you need to know exactly what the decedent's wishes are before you even get started. You- let's say they have pets, something like that, and they have a specific place they want those to go. Those are things that need to happen right away before the will's even probated. So you need to, if at all possible, locate the will and at least know what you're in for and who you're going to be answering to, and assets, like I said, that may need to be dealt with right now, even though you don't have the authority from the probate court yet, but it needs to be dealt with right now. So,
And sometimes contained within someone's estate plan is also a disposition of remains too. And that might be something, obviously, that you need to look at quickly after someone passes away to make sure that you dispose of their body in the way in which they intended, whether it be, cremation or burial or even a Viking funeral. Someone wants to
exactly.
be doused in gasoline, put on a raft, and then fired at with fiery arrows in the middle of a lake. And that, you need to know that before you dispose of their body. Um, so we've covered this a lot of times, but this is still a question that comes up. What happens if there's not a will?
If there's not a will, then the state of Texas and the estates code provide for who the heirs are of a person who died without a will. And it takes into account children by a prior marriage, whether the person is currently married, or or if they're widowed, or if they're divorced. And so unfortunately, it may not be what the decedent wanted, but the decedent should have drafted a will if they really wanted their wishes, and everything to go the way they wanted to. So we can help with that, and it's called an application to determine heirship. And you go in, you prove up the person has died, you prove up who their relatives are based on the chart that tells you where everything goes, and you'll get a judgment from the court, judgment declaring heirship, which tells you who inherits and at what percentage they inherit from the estate.
And this is something that we touched on a little bit in the last podcast toward the end, but you know, we're obviously not therapists, although it does say attorney and counselor. But in what ways can we assist with helping the family kind of deal with emotions running high after someone passes away?
One of the things I tend to do is, an executor may be in the middle of some of those tensions that are running high. They may be one of the children or something. I personally take calls from all of them, and you know, I'm empathetic, uh, having done this for 24 years and having done hundreds and hundreds of estates. I really do. Maybe I don't understand what they're going. I understand what they're going through. I may not feel it myself, but I understand it, and I think I'm good at the counseling part, at explaining to them that let's get through this so that you can then deal with your grief. Because when you're having these conflicts or these probate proceedings, that's business, and that's business to us. Um, and sometimes people just need to get that over with so that they can deal with their grief and roll on. And I think, explaining that to them in a very kind way, um, and trying to keep the emotions lowered as much as possible, is it, that's how I avoid, conflicts or, people getting angry.
Yeah, I try to remember back to the time that I had to probate my grandmother's will, which was probably one of the hardest things I'd ever done. Such that the court was very kind to put me at the end of the docket and make sure that the courtroom is cleared, so that I could do it, in some relative level of privacy. But yeah, I mean, I think back to that and think about how hard that was, and then try to um, relate that to uh, the individuals that are in front of me that are talking about the death of their loved one. So
Yeah, my mother died very unexpectedly 2 years ago, very unexpectedly, and of course named as executor, and I had to hire a probate attorney because I could not function. And this is what I do all day every day, but I just couldn't function with it. And I had them drafting all my documents, handling court appearances. I would have cratered if I had to do it. So yeah.
yeah, you know, one of the questions we get asked kind of often is about creditors, and why is it so important to notify creditors of the death of the decedent as quickly as possible?
Oh, one reason is sometimes you can get particular debts cleared, um, and have them barred if the people do not file claims properly, and that could be a whole nother podcast. But there's also the reality, and before you start spending a lot, and definitely before you distribute, you need to know that all the debts are paid. Worst case for an executor is to go through all of this and distribute everything and then find out you owe $20,000 somewhere. Now you're going back to beneficiaries. And although there is a mechanism to get money back from them, they might have spent it. So the sooner you can notify all creditors and identify them and negotiate those claims or pay those claims, it's better, so that now you're dealing with just the expenses of probate and um, ultimate distribution. As an overview, what's the role of an executor, and how does a probate attorney assist them?
So their job is to manage the estate fundamentally. It's to gather assets, identify problems related to the assets, um, report those assets to the court, recover any assets that need to be recovered, and then obviously distribute them according to the terms of the will to the beneficiary. So, we help with that process. There's a I think we talked about this in the past, identifying what assets are probate and which assets are non-probate, verifying that the alleged non-probate assets have been designated properly, issues with real estate, and whether or not the decedent owned 100% or 50% or some other percentage of that property. So, we have to help the executor through the entire process from filing the will, getting appointed, all the way through, at least in my opinion, um, distributing, providing a rudimentary accounting to the beneficiaries so that there's that level of transparency that you and I are so conscious of. And then also ensuring that they protect themselves from unnecessary liability.
How can an executor or personal representative of an estate, how can they handle disagreements among family members over the will, and how do we help with that?
In the movies, there's always this, you know exactly where I'm going with this too. In the movie, there's always this grand ceremony made of the reading of the will, right? And I think they're, maybe one of the, what was the movie with the Daniel Craig where he was the detective, and Glass Onion was the recent one, but the previous one, they made a big to do over the reading of the will, and the various beneficiaries that were dissatisfied with how the estate was left. That doesn't really happen. I've never done a reading of a will. Maybe at some point in the future that will become necessary. But one thing that you can do is, again, keep harping on this, is being transparent with the family. Um, at an initial meeting, or the meeting, a secondary meeting after you've met with the executor, maybe have, and we've done this before, have meetings with the whole family to explain kind of the process, and and making sure that if this does turn into litigation, that you keep the conversation somewhat surface, because you don't want to get into anything that's privileged, because then the privilege gets waived. But at least in terms of explaining what, in your opinion, the will says, how the process is going to go, when they can expect distributions, things like that. I think that's the best way to mitigate potential disputes, or even if people are already angry about it, maybe lower the temperature amongst the family members.
What should be done about any outstanding debts of the decedent? We kind of touched on this earlier, but
Yeah, I mean, it's the executor's job to identify those things. And, a lot of times family members don't exactly know. So one of the things that we have them do is redirect the mail and make sure they check the mail. And sort of once you've gone through two cycles, 2 months worth of bills, you can pretty, uh, pretty accurately determine what bills there are at the decedent and be able to address those. But the estates code has a procedure for dealing with creditors. And if they're secured, you're required to send a letter out to them notifying of the death. If they're unsecured, you don't necessarily have to, but it's always a good idea to at least notify them. And we always have different creditors call and ask us, "Hey, just checking on the status of the estate. What's going on?" And I always tell them the same thing, which is, we have not made a determination at this point of what the posture of the estate is, whether or not your claim will be able to be paid. But as soon as we know something, we will let you know. So really identifying them and then determining what classification they fit into within the estates codes 1 through 8 classification is probably the best first step in dealing with the debts.
and something we haven't talked about, I don't think in all of our podcasts yet, is how do you handle the deceased digital assets and online accounts?
So, if you go onto our website and look, you will see a interview that I did with the news probably, 10 years ago, about dealing with digital assets. At that time, the law was not really formed about how you deal with that. And so I would say probably 75% of what I said in that interview was speculation. Now, companies like Google and Apple have a form that you can fill out online that allows you to designate your, you know, I don't remember what the terminology is that they call it, but I'll call it your post-death people that can have access to your Facebook or Google or Apple accounts, so that they can get in there and look. So each one of those companies over the last 10 years or so has gotten wise to the fact that is going to be an issue. And even stuff. I mean, I gave a lecture 2 years ago about Bitcoin and digital wallets, and I can tell you for a fact that because there are a couple horror stories about this, that if the decedent does not leave the key in a place, and the key is digital, it's numerical or alphanumeric code, in a place where someone can find it to unlock that wallet. I think you got three chances and then it's gone. And there was a story about a guy, I think in Great Britain, that tossed out the drive that he had the secure key on, and had about $50 million worth of Bitcoin, and then subsequently went and dug through the dump to see if he could find it. So, you know, when people are doing planning, they need to make sure that not only they're dealing with their tangible assets, but also the digital ones, and give the executor some clue as to where they could find that information, either on their computer, or for Pete's sake, I mean, just write it down on a piece of paper and stick it under your desk. But give someone direction to find it, because there have also been horror stories about people setting up these, Indiana Jones style operations to recover the key to the digital wallet, which have sometimes been successful, but harrowing, and other times been unsuccessful, and then disappointing. So I would say just make sure that you tell your estate planner everything that you've got, where it is, and make sure that at least one person who's alive is going to be able to figure out where all your digital assets are.
Why is it important to file a final tax return for a decedent?
Well, regardless of what the estates code says, the IRS gets paid first. We all know that, right? I mean, they're the number one, they're the super creditor. So, uh, it's going to be hard to make a distribution to beneficiaries if there is an inordinate amount of unpaid IRS debt. So, identifying that, and again, back with the getting 2 months worth of mail, the IRS probably sends a letter out on past due stuff, once every couple months. So you should be able to identify that. But nobody gets paid. There is even cases out there that say that the attorney doesn't get paid, and much to our dismay, before the IRS gets paid. So as soon as you get that tax return done, the better off you are, because you'll know exactly what you're left over with, as far as the estate goes. Something that we dealt with earlier, but this might require a little bit more information, is insurance claims. They're typically non-probate assets, because they're usually beneficiary designations. But how do we help clients deal with those?
A lot of it is just helping them navigate the forms to make a claim if they're a beneficiary under the life insurance policy. First we identify which policies the decedent had, who the beneficiaries of those policies are, get the claim forms and fill those out. Usually, a lot of times the client can do them themselves. The beneficiaries can do it themselves. Where it can get tricky is when life insurance is left to minors. And a lot of these insurance companies I don't know of anyone that doesn't. They require either a guardianship over that child, or that the money go into some type of trust. They're not just going to pay the parent of the child the life insurance money. So we can help navigate that and find the least restrictive way to set up a trust or some type of an account for the minor beneficiaries, that will satisfy the requirements of the life insurance company.
Um, and another question that we get asked pretty often is, why do I have to do this inventory? Do I need to get stuff appraised? And um, other than the fact that a court requires you to file an inventory, why is it important for the executor or administrator to do an estate inventory, and in some cases an appraisal?
One, if you're going to be You need to know the value of the estate if you're going to divide it, such as some wills say 30% here, 30% here, 40% here, and don't leave necessarily specific items to specific people. But either way, you need to know what the value of the estate is, and that you've paid all the taxes based on the value of the estate. And, if it's a strange piece of property, and that could be personal or real property, you need to get that appraised. That protects the executor in knowing exactly what the value is. Let's say if you're going to sell it, especially, you need to know what the value is. And the more you can back up what you're doing with appraisals and the inventory, it's going to make your job a lot easier.
Can, and you and I both have strong opinions about this, but can probate be avoided if there is a living trust? If someone does a trust, can you avoid having to go to probate court?
Yes, you can. Um, might not always work. You might have forgotten to put an asset into the trust. But then again, there are documents that you leave. You can leave a will that says everything I own goes into this trust, but that's still probating the will. Um, so yes, you can. But there's other legal matters you still may need to handle other than just the trust. I have an estate right now. It's not my estate, but decedent left everything into a trust for his wife. Well, we believe the decedent owed us a lot of money prior to that. So, the wife, the surviving spouse in that particular case, she's still having to deal with all of these issues, even though they had a living trust, because we're suing her. So there's still things that might need to happen outside the living trust. And so it's important to at least consult with a probate attorney to know if you have hit every asset and to make sure everything's being done correctly.
This is a especially in a community property state like Texas. How do we deal with jointly owned property after death? Right. I mean that comes up a lot, and sometimes it's in a second marriage situation where stepmom maybe that kids don't like still's going to own the house and have a right to live in it. I mean, how do we deal with those things?
Well, jointly owned property between the husband and wife, that's usually going to pass to the surviving owner of the jointly owned property. There's been case law on joint accounts where you only own it to the extent that you've put money into it. So that would be an exception. And sometimes the children, let's say it's a second marriage, the children want to say, well, yes, there's $1 million there, but it was all my father's. She didn't put anything into that joint account. And so it should not all go to her. It should, go into his estate, something like that. And again, it depends on how it's titled. Was it just a joint account? Was it joint account with right of the survivorship? The house could be titled in just one person's name, but if it was bought during the marriage, then it's jointly owned or community here in Texas. So again, that's the importance of having a probate attorney to help you clarify those issues. Who does own it and to what extent they own it?
And sort of going along with that, how do we help clients deal with the decedent's real estate holdings? Sometimes it's not just owned by the individual, it's owned by the individual's corporation or their trust or whatever. So how do we help navigate that issue of real estate owned by the decedent or owned by something owned by the decedent?
Well, that's could be two different issues there. If it's a corporation owned by the decedent and the corporation owns the real property, then it's a question of what happens to the corporation upon the decedent's death. And therein that flows down to the underlying assets. If it's just a decedent having title to real property, it's, we see this so much in Texas, a huge ranch. And, it's owned by three brothers, and your father's one of those brothers, and he dies. And so what happens to his third of that ranch? And actually, I'm dealing with one of those cases right now where the ranch is a shooting ranch and a hunting ranch. And somebody died, and my the heirs of the decedent don't want to have anything to do with this hunting ranch. They want, they want out of it. And so it's helping them navigate that. And, can we force the sale? Can we force them to buy us out? That, handling those type of things. We kind of touched on this, or you at least mentioned it, that when you were talking about the class of claims and how what should be done about unpaid medical bills of the decedent.
Well, the first thing that should be done is you should call the hospital and let them know that the person is dead. And sometimes those medical bills will magically disappear. Sometimes there are different hospitals that will just, sort of as a matter of course, write off the bills because, one, they can get a tax break for that, but two, I mean, it's just sort of it's kind of a considerate thing to do when someone passes away. But in the instance that that is not the case, the estates code provides that the first $15,000 of expenses of last illness are considered a class one claim, which means they get paid first along with $15,000 worth of funeral expenses. Everything above that 15 drops down into the Class A claim for unsecured creditors, which includes also credit cards and things of that nature. So um, I say, first thing, call the hospital, see if they'll just discharge the debt. If not, gather all of them together, and the first 15,000, assuming that they are related to the expenses of the last illness, will be paid also proportionately. So if all the bills aren't from the same place, then you have to look at them and do that, X over 100 analysis to figure out what part of the $15,000 that medical bill is. But that's how you sort of deal with those.
Well, along with that, how can a surviving spouse or children claim any exemptions from creditors?
Well, children are not responsible for the debts of their parents. Surviving spouses, unfortunately, are because, it's just like it's a community property state. The surviving spouse has joint and several liability with the decedent for those debts. And so, one of the things that we do or have done in the past is, oh, okay, well, I'm going to get the estate, I'm going to get this claim barred in the estate so that, the estate's not responsible for it. But the problem is that if you get the claim barred in the estate, then all that's going to happen is that then the entire debt will then be owed by the surviving spouse, which, let's be honest, they're dealing with enough as it is, right? They lost their loved one. So the best way to handle that is to try to negotiate a deal with the creditor within the estate to either minimize that debt or wipe it out entirely, with the understanding that it's not going to fall back on the spouse. But one question that we get all the time from children of the decedent is, well, if the estate doesn't have money, am I going to pay my dad's debts? No, there's, off the top of my head, cannot think of a circumstance where a child is responsible for their parents' debts unless they're, I mean, there might be some exceptions, but as a general rule, no. So it's really the surviving spouse we have to worry about that instance.
And we've touched a little bit on this, but how do you handle the deceased business interest?
So, you and I have a nasty case involving a decedent's business interests in a very poorly drafted LLC agreement. You know, one thing that you need to look at when you're dealing with business interests is what type of interest it is. So if it's a DBA, then it's just the decedent. There's nothing behind that. But if it's an LLC, which is a disregarded entity in Texas, which means it either falls under the rules relating to a partnership or the rules relating to a corporation, You have to look at the agreement first because when I draft corporate agreements, I really try to put dispositive provisions in the corporate agreement, which then makes it a non-probate asset. Because again, it's a contractual arrangement entered into during the life of the decedent that supersedes whatever happens in the will. So if there's a corporate bylaws that say upon the death of one of the owners, then it all goes to the other owner, or the other owner has 6 months to buy out, to make an offer to purchase the shares from the decedent's spouse or whatever it says. That's the first thing you need to look and see if the partnership or the corporate agreement or the LLC agreement has a buyout provision or if it has a dispositive provision about that member's interests. If not, then assuming there is a partner or other members of the corporation, then you have to get those that value appraised and then work out getting having it paid out however it's supposed to be paid out according to the agreement.
What happens if the decedent was dealing with some outstanding legal claims? Either they're bringing them or they're being sued, and then they die. Kind of what happens to those claims?
Well, they survive. You have to file what's called a stare facias in that particular, assuming that the claim has evolved into a lawsuit. But you have to notify the court that that person's dead, and then figure out how to how you want to pursue or defend those claims. Um, you'll have to get a personal representative appointed to stand in the shoes of the decedent, and then either prosecute that lawsuit for maybe personal injury or wrongful death, or vice versa, defend the lawsuit like you defended me recently, where I was appointed as a administrator for someone who was deceased who was allegedly responsible for an accident. The court had to appoint me as the administrator, and then I stood in the shoes to deal with the insurance and things of that nature. So really, that's you got to get an executor appointed. Well, first step is notify that particular court that the person is deceased, and then once you've done that, you have to get a personal representative appointed in a reasonable time to sub in for the decedent.
How can a probate attorney help expedite this whole process that we've been talking about?
Well, I mean, the first thing is, and I think that we've done a better and better job over time, but if a client brings a will into you to get filed for probate, get it filed either that day or the next business day so that, you know, we've at least done our part in ensuring that the process has begun. And then, as soon as the court will allow, and that depends on what jurisdiction you're in and whose court you're in, whether or not you have to wait the 10 days for the will to be posted before you can schedule a hearing. But, make sure that either you or your staff get on the court to get a date as quickly as possible. So, I mean, frankly, that's half the battle. Half the battle is getting the hearing, the will filed or the independent administration filed, and then getting a hearing set. After that, in the interim time between when you file and when you have the hearing, start trying to gather up the assets and information from the client to determine, what would go in the inventory. And I try really hard at the beginning of a case when I draft the application for probate or for independent administration to also draft all the other documents that have to be filed in the case with blanks, so that it can easily be filled in and then filed as soon as possible. I mean, we don't make any representations or warranties to clients about when things can and can't get done because, half of the time it's going to depend on them getting us the information timely. But assuming that they do, we want to push things along as fast as possible so we don't incur additional costs for them, and so that we can move their case through and they can have that catharsis sooner than later. So this is a question that comes up all the time. how do we deal with, as probate attorneys, as probate litigators, how do we deal with a circumstance where there are multiple wills or conflicting estate planning documents?
Well, we have to determine which will is the valid will, obviously. An example would be you have a will done in 1990, and then in 1995, the decedent does a different will, which usually has the language at the top, I hereby revoke all prior wills, which would mean that the 1990 is not good anymore. Now the 1995 will is good. But I had a situation where that happened. And then let's say in the year 2000, they did a codicil to the first will. So that in our world republishes that first will. So what happens to the second will? And that's why you need a probate attorney to determine which will is valid. A lot of times in wills, the decedent will say, I'll leave a list of my personal property and where I want that to go. And they can amend that list over and over and over again, and determining which list is the valid one. And unfortunately, in those situations, a lot of times you're going to end up in court because somebody's going to like one will better than the other will. I mean, we call it the wall of wills. I've seen that done before where there's 7 or 8 wills and you got to knock out the first one. The second, you just knock them down until you get to the one that the court or the jury believes is the proper will.
Yeah, and we have this circumstance right now in a case. We're not going to get into the name of the case or anything, but one of the issues is temporal. Which will was which document was drafted first. An invalid will does not revoke a prior will, right?
Right.
What is the process for selling estate assets to pay off debts of an estate? I mean, there's an order of priority, right?
Whoa, correct. First of all, if specific assets were devised to specific heirs, you want to avoid selling those off to pay the debts. Because once you turn it into money, they don't get that money. It's just money that's in the estate. So you want to avoid that as much as you can. You need to, again, as we discussed earlier, know the proper value of certain assets before you sell them to make sure you're getting fair market value for those particular assets. If you have to, if there's 2 pieces of land and one goes to one beneficiary and one goes to the other, it's probably a good idea to sell both if you've got to pay off debts so that one person doesn't get land and the other one doesn't. I mean, you have to be very cognizant of the fact that specific assets could have been left to specific people. And you need to try to honor the decedent's wishes as best you can, but also paying the debts.
And I have a funny story about this, but how do you handle disputes over sentimental items? This is one of the worst things that happens to us where we get into mediation, we've gotten, all the money, the property, whatever split up, and then there's this sentimental item that has no value except sentimental value. How do you handle that?
You talking about grandmother's platter? No? Was that it?
Yeah, grandmother's platter, or no, mine was the elephant lamp, the famous
Okay.
elephant lamp.
Okay, ours was the platter that grandmother used to bring the turkey out in. Okay. And there was mediation, probably 6, 7 attorneys sitting around this table, all making between 400, 800 an hour, arguing over the last asset, which it was the platter that grandmother brought out the turkey on. And this had been going on all day, and one of the attorneys stood up and threw it on the floor. And, of course, the first thing is I hope your malpractice insurance is up to speed on this one, but it's tough. When I've had to deal with some of these, it's trying to find out why it's sentimental to someone. Have that discussion. Why is this sentimental to you? Why is this sentimental to you? And sometimes you can resolve the disputes just by someone being able to say, hey, this is why I want this. And you bargaining back and forth. I want this, I'll give you this, that type of thing. But it is a tough area to get through. That's one of the toughest, is when it's not of a great deal of value, but just sentimental.
Yeah, I had an estate where I was the administrator, and it was three brothers, and they literally all wanted the same personal property items. And so uh, went to the judge and asked, you know, how do I resolve this? And he was like, that's simple. So you have three of them, you get a hat, put three numbers in it. They draw their number. Each one of them can, you're going to hold uh, a meeting at the house. Everybody's going to stand outside. You're going to, let them go in order of the number they drew into the house and grab one thing and come back out until they're done. And we did that. And of course, one of them got the elephant lamp. The other two were pissed off about it. Um, and, you know, if I had had the inclination, I would have gone over there beforehand and the elephant lamp would have disappeared. But no, I mean, that's how we had to do it. We had to do the, drawing the numbers out of a hat. And this is for 40 and 50-year-old men who are not mature enough to make a decision. I mean, my grandmother passed, and I think my brother and I had some things in our house that we were sentimental about, but not to the point of fighting over it. So anyway, and then you know we've talked about this before, but how do you deal with the insolvency issue in an estate? How do you handle that?
Okay, well, this is where the debts exceed the assets. Again, we've talked about the priority of claims, and obviously you follow that. But let's say that's the last, medical bills dealing with the last illness of the decedent, and it's just gathering all of those claims and paying it in percentage to what assets that you do have. You get down to the bottom and you have $25,000 worth of credit card bills, and you tell them, look, I have 3,000. I don't have 25,000. So I'm going to split it up among you guys, and you get them to sign a release too, to make sure that never comes back on anyone. But it's just satisfying the debts in proportion to the assets of the estate and getting releases from everyone. You're negotiating. You're negotiating with credit card companies. You're negotiating with, whomever these debts belong to.
Sort of a sub issue of that is people that come to us and say, I'm pretty sure the estate's insolvent. Why do I want to probate the will? Or why do I want to open an estate?
Well, and I guess sometimes you don't have to. Let's say it's just a parent and one child. Then, let it go. Don't probate the estate. But if you're the surviving spouse, you could be responsible for some of these debts. So you definitely want to clean it up. I helped a friend of mine whose husband died, and there were just all kinds of medical liens. And, we discussed the not probating it. But she was the spouse, and she was going to be responsible for these debts. So we went ahead and probated it and told them there wasn't money in the estate, and got most of those wiped out.
So the closing question, which kind of addressed last time, but this is never a bad thing to kind of address, which is, as the probate attorney and counselor, what can we do to give our client peace of mind during this difficult time for that, the loss of a loved one?
We do our job. That's going to make it easier for them. We make sure everything's filed properly with the courts. We handle all the paperwork, gathering everything. But then again, when I have an independent executor, I let them do as much of the work themselves as they'd like. It's a push and pull on that type of thing. but we can do basically everything for them. So they're not really worrying about this process or disputes, or, I mean, we can just take all of that off the table from them so that they can grieve and heal. Don't want to give too much information, but I have one case right now where the decedent was murdered by her husband, and there's a very, very young minor child, and the decedent's parents are trying to go through this probate process and now also raise a very young child at, their age. And, when we were hired, it was, I have so much on my plate trying to take care of this child. I need someone else to handle all this everything else that's going on. So, we've brought those clients quite a bit of peace of mind. We answer their questions right away. We take things off their plate, put them on ours as quickly as we can. We deal with notices in the mail. We're just making it as easy as we possibly can for them to, raise this child. And not to mention the legal issue of, the son-in-law being the murderer. So, I mean, we have it from that extreme to just simple disputes, but the more we can do and take it off their plate, it's just going to make it a lot easier on them.
Yeah. Well, I think that hit all of our the top 25 questions that we get fairly often. Is there anything else that you think you want to add or before we sign off for today?
Everything we've talked about is things that have to be navigated during the probate process at a time when emotions are running high. And that is never easy. And so by hiring a knowledgeable probate attorney, that just gives you a peace of mind. When I meet with clients and we agree to represent them, one of the things I say to them is, go get some rest. Let me worry about this. You get some good sleep. Don't toss and turn about this anymore. We've got you handled. So.
Yeah, we are going to step in the gap for them and help them navigate the situation and have nothing to worry about so that they can, rest easy and make sure that whatever the decedent wanted gets carried out in a way that's respectful, that's transparent, and also beneficial to everybody that they intended to receive part of their estate. So, Stacy Kelly, Keith Morris, signing off for today. Great, thank you for watching, and look forward to the next episode. But again, this is things that you should know before you go. Thank you very much.
Now, before you go, learn more about how Stacy and Keith can help protect you by calling or visiting us on the web. Links to our website and phone number are in the show notes. The information on this podcast is for general information purposes only. Nothing on this podcast should be taken as legal advice for any individual case or situation. This information is not intended to create, and receipt, viewing, or listening does not constitute an attorney-client relationship.